And I believe that concludes our opening statements by the members, so we'll now begin consideration of the bill. The chair now calls up H.R. 2749, the Food Safety Enhancement Act of 2009, and the clerk will report the title of the bill.
H.R. 2749, a bill to amend the Federal Food, Drug, and Cosmetic Act to improve the safety of food in the global market and for other purposes.
Without objection, the first reading of the bill will be dispensed with. Bill is now considered as read, and without objection, the bill will be open to amendment at any point, and the chair now recognizes himself to offer a manager's amendment to H.R. 2749 in the form of an amendment in the nature of a substitute, and the clerk will report the amendment.
Amendment in the nature of an amendment in the nature of a substitute to H.R. 2749 offered by Mr. Pallone of New Jersey.
Without objection, the manager's amendment will be considered as read in original text for the purpose of amendment, and I'll recognize myself for a statement on the amendment in the nature of a substitute at this time. This is a bipartisan amendment that takes into account suggestions by my colleagues on the other side of the aisle, input from stakeholders, as well as some smaller, more technical changes. And I'm pleased that we have been able to work in this fashion and that we've come to an agreement on the issues contained in this amendment. I do recognize, however, that there are a number of outstanding issues that we have not yet addressed. Some of the members mentioned those in their opening statements, and I hope that we will continue to work in a bipartisan fashion on those issues as we move to full committee markup, as Mr. Waxman has said, next week. I also want to mention that there are a number of questions from our hearing last week that have not yet been answered by our panelists. We hope to get those answers to the members who requested them as soon as possible, and with ample time left before the full committee markup next week. This amendment addresses a number of smaller, more technical issues, but I do want to highlight 4 changes that I feel are very important. The first pertains to the fees put forth by the bill as introduced. After conversations with members on both sides of the aisle, as well as long conversations with the key stakeholder groups, we've reduced the fee amount by half, changing it from $1,000 per facility to $500 per facility. We have included a cap on the fees so that no one organization will have to pay more than $175,000 per year. And finally, in response to some concerns we heard during the hearing last week on how the revenue generated from fees would be allocated, we changed the fee section to include a consultation in the form of a public meeting so that stakeholders will be able to weigh in on how the fee revenue will actually be spent. Now, the second change puts in place due process protections as to who at the FDA can exercise select enforcement authorities. This, too, is in response to concerns raised that these authorities should only be used in specific situations and that the decision to exercise them should be limited to certain individuals. We also clarified the traceability language to make clear that before the FDA can issue a regulation on a traceback system, they must take into account the views of the stakeholders, the information gathered in the information gathering period, as well as the results from the pilot study on traceability. And finally, we have included language that would allow the FDA to make accommodations for small businesses. In the preventive control sections, we added language that directs the Secretary to take into account small businesses when issuing guidance or regulations on preventive controls, and also to issue guidance specifically for small businesses on how to implement preventive controls in accordance with the bill. This is in addition to the already existing longer implementation period for small businesses, and we added similar language in the fresh produce standards section where we direct the Secretary to consider the impact of standards requirements on small farms. In sum, this bipartisan amendment addresses many of the concerns we heard from members on this committee, as well as from stakeholders. Again, it has not addressed all the issues that we're working on, and we hope to continue this very productive process with our minority colleagues as we move forward with the bill next week. I support this amendment, and I urge my colleagues on both sides of the aisle to do so, and I want to thank everyone for all the cooperation we received on this. Now, does any member seek recognition to offer, well, let me say, does any other member would like to speak on the manager's amendment? Gentleman from Kentucky.
Yes, Mr. Chairman, thank you. I just, for clarification purposes, would like to ask just a few couple of questions to legal counsel, if I could.
Sure.
As you know, in the rural areas, we have a lot of small grocery stores, convenience stores, and the first question I want to ask you, will all retailers be subject to mandatory recalls?
Counsel?
What? 417. Mr. Whitfield, your question refers to recall, the recall authority granted to FDA under Section 111
Yes.
of the legislation. And your question was,
Does it apply to all retailers?
the authority under Section 111 refers to responsible parties as defined by the Act, and which is also as defined in the Federal Food, Drug, and Cosmetic Act, and is also amended by the legislation that we're considering this morning. Amending this morning under Section 112 of the legislation before us, and responsible party as amended by the legislation before us is defined as a person who owns, operates, or is an agent of a restaurant or other retail food establishment. So yes, retailers are covered under this.
So convenience stores, whatever. Okay. Now, second question. In Section 112, it certainly makes these retailers subject to the food registry, which means that they will be required to contact the FDA if they become aware of a so-called reportable food, which is defined in the Act. And I was just wondering, maybe this pertains to regulations established by FDA, but trying to contact the FDA and report problem foods, is there anything in the language of the bill that requires the FDA to have a 800 number for reporting purposes?
There's nothing in the legislation to that effect.
Okay. All right. Thank you, Mr. Chairman.
Thank you. Does any other member seek to address the manager's amendment? Gentleman from, anybody? Gentleman from Indiana?
I have an amendment at the desk.
Well, before we proceed, let me just see if anyone else wants to address the manager's amendment.
Mr.
Yes.
Chairman,
Yes.
I seek recognition for strike
Mr. Chairman?
words. I'll be very brief. I'd just like to say, Mr. Chairman, that this manager's amendment represents some very careful work by the staff to try and accommodate concerns set forth by my Republican colleagues. And I would note that we intend to continue working on those matters so that we can get this to be a bipartisan bill in which all of us are satisfied. Thank you, Mr. Chairman. Yield back the balance of my time.
Thank you, Chairman Dingell. The gentleman from Texas, Mr. Burgess?
Yes, Mr. Chairman, I just had a question for council too, if I could.
Proceed, sure.
On the Section 107, under Section 107, farms will be excluded from the traceability requirements if they sell directly to the consumer. Now, are there any parameters drawn around the size of the farm or the nature of the consumer as far as the traceability requirements under the bill? For example, could ConAgra sell 100,000 pounds of tomatoes to one of the school districts, where that is a farm selling directly to the consumer? And would that be exempt from the traceability requirements?
Your question was, are there any parameters around the size of the farm as it relates to
Correct.
this
Are
exemption?
there any definitions there that I'm missing? And I apologize because I don't have the correct page. I just got the new manager's amendment, the copy that I had last night. This was on page 46, and it addresses direct sales by farms. And it says food is exempt from this requirement of this subsection if the food is, 1, produced on a farm, 2, sold by the operator, owner, or agent in charge of such a farm directly to the consumer or restaurant or grocery store. So, in other words, could ConAgra, a huge farm, sell 100,000 pounds of tomatoes to the Denton Independent School District back home?
There is no specific language in the legislation that addresses the size of a farm.
So that would be exempt from the traceability requirements.
That. What are you referencing?
That sale, those tomatoes, that 100,000 pounds of tomatoes would be exempt from the traceability requirements.
Yes.
And again,
What was your question again, Mr. Burgess? If in the example that you provided,
well, under Section 107, farms will be excluded if they
Yes.
sell directly to the consumer. But we really don't draw any parameters on, I mean, and intuitively, I think of a small farm that's selling at the farmer's market back home on Saturday morning. But that's a concept, but what about the other concept? A large industrial farm that is selling massive amounts of produce to a large consumer like a school district, hospital. Where is the traceability requirement for that really what would be a very large commercial sale?
under the legislation, the exemption that you are referencing only states that food is exempt from the requirements if such food is produced on a farm and sold by the owner, operator, or agent in charge of such farm directly to a consumer or to a restaurant or grocery store. There is no additional language related in the legislation related to the actual size of the farm.
Well, Mr. Chairman, I would just point out, and I'm not certain if this represents a vulnerability in the bill, but I would respectfully ask that we work on this between now and the full committee markup and see if we cannot refine this definition, because it seems like that's a pretty large gap.
Will the gentleman
I'd
yield?
be happy to yield.
I agree we should look at the language, because the intention of this language is to really address farmers markets that are dealing small producers in farmers markets and so on. And you're right, if there's a large corporate entity that's selling to another large corporate entity directly, we don't want this to be too broad of a loophole. So we certainly will be happy to work with the gentleman. I appreciate you raising.
Gentlemen, yield.
I'll be happy to
Mr.
yield.
Waxman.
Thank you for yielding to me. When there are multiple steps, that's where the traceability becomes important. Where there's only one step, farmer to the consumer directly, that there's an exemption. I think that was the policy behind this, but I think we ought to look at it and rethink this in any way you think appropriate between now and the full committee.
Thank you, Mr. Chairman. I appreciate the consideration. I'll yield back.
Thank the gentleman from Texas. Unless anyone else wants to comment on the substitute, I'm going to move
Chairman?
to amendments. Mr. Boyer?
I just have one question of council, if I may.
Sure.
I wanted to, on the issue on full pedigree, so to council, with regard to retailers in section 107, will retailers be subject to full pedigree traceability requirements of section 107? Is this all retailers?
In section 107 of the legislation, on page 46, there is a specific reference to food that relates to restaurants and grocery stores. And the language specifically says that they shall keep records documenting the farm that was the source of the food. So that's the only records that they would be required to maintain.
Will, on the issues on quarantines to council, will retailers be subject to quarantine?
Would the gentleman yield to me?
Sure.
Mr.
I think
Bingham?
we have here, I'd like to kind of explain how this works here. First of all, direct sales by farms are not subject to some of the traceability requirements. But if you follow on down, you will find that that exemption is, first of all, applicable only to the foods produced on a farm. Second, sold by the owner, operator, or agent in charge of such farm directly to a consumer or to a restaurant or grocery store. If you come over to the top of page 47, you will see then restaurants and grocery stores. For food covered by an exemption under subparagraph A, restaurants and grocery stores shall keep records documenting the farm that was the source of the food. So you have a way in which you are tracing this. It is different. It is intended not to burden the farmer, but at the same time to see to it that you get the results you want, which is traceability of the food. And I thank the gentleman for yielding.
I thank you. With regard to the issue on quarantines and its impact upon retailers, to council?
Yes.
It is meant to apply also to retail of any size.
Under section 133, there is no language that relates to exemptions for retailers. The quarantine authority under this section relates to geographic areas.
All right. Thank you very much. I yield back.
Thank you. We'll proceed now to amendments, and the gentleman from India had an amendment. I recognize the gentleman.
Thank you very much. The amendment would be Booyer number 23.
Clerk will report the amendment.
Amendment to the amendment in the nature of substitute to H.R. 2749, offered by Mr. Booyer.
I ask
Add
unanimous
at the end.
consent that the amendment be read.
So ordered. The amendment is being distributed and without objection will be considered as read, and I'll recognize the gentleman to comment on his amendment.
Mr. Chairman, I believe there is strong support from both sides of the aisle here in this committee to ensure that alcohol regulations remain under the jurisdiction of the Tax and Trade Bureau. The FDA, in answers to questions that I had submitted to them, the FDA supports TTB's continued regulation of alcoholic beverages as set forth under the MOU between FDA and ATF. As stated in the 1987 MOU, both agencies have authority with regard to alcoholic beverages. Pursuant to the Federal Alcohol Administration Act, FAA Act, and the Internal Revenue Code of 1986, TTB has authority over distilled spirits, wines, and malt beverages products, both domestic and imported. Currently, TTB ensures that alcoholic beverages are produced, advertised, and marketed in accordance with federal law. TTB also is charged with reviewing applications, ensuring permits for distilled spirits and wine operations regarding the production, packaging, and storage of alcohol, and ensuring that the labeling and advertising of alcoholic beverages are not misleading and that they provide adequate information to the consumer. In order to ensure that imported alcohol products are safe from contamination, TTB conducts background checks and looks at each potential importer's financial standing, trade connections, and business experience to decide whether or not the importer is likely to comply with federal law. Additionally, TTB requires, quote, certificates of label approval for every alcoholic beverage before it can be removed from customs custody or into domestic commerce, end quote. The TTB also requires pre-imported samples and routine market basket testing, where TTB investigators pull product samples from all levels of the distribution chain and send it to their labs to verify that the product is authentic and safe. TTB has a strong and extensive hold on the regulation of alcoholic beverage industry, collecting approximately $7 billion in alcohol excise taxes every year. The FDA stated in response to my question that it supports, as I said, the MOU between the FDA and ATF. FDA further stated that we believe there is no reason the draft legislation should alter the current regulatory framework. They also believe that it doesn't. It's important to note that TTB works closely with other federal agencies to ensure the safety of alcoholic beverages. These agencies include Customs and Border Protection to ensure the safety of imported alcoholic beverages, the FDA to seek advice on health and safety issues, and the USDA when alcohol products bear an organic claim on their labeling, and the U.S. Trade Representative when trade issues arise, and the Federal Trade Commission regarding alcohol advertising. Additionally, TTB works with state agencies and has memorandums of understanding with foreign countries. For this reason, I believe that TTB should continue to operate as the primary regulator of alcoholic beverages, and I believe there is strong support on this committee for that to remain in place. This is a classic, if it's not broken, don't break it. So I believe that this is an agency that has an excellent track record, Mr. Chairman, with working with many different agencies to protect the American people, and I believe that breaking this paradigm could cause a situation whereby we would be multiplicious and redundant. My amendment is supported by, obviously, brewers, distillers, and beer and wine wholesalers. That should be no surprise. But I think this is an amendment, Mr. Chairman. I'm hopeful that you'll give it strong consideration, and I yield back my time.
Mr. Chairman?
Thank you. Yes, Mr. Chairman Dingell.
I'd like to strike the requisite number of words.
Recognize the chairman.
And I thank you for your courtesy, Mr. Chairman. I'd like to direct my comments to the author of the amendment. Tell my good friend that he's referred to the Memorandum of Understanding between FDA and the Bureau of Alcohol, Tobacco, and Firearms, ATF, under which ATF takes the lead on enforcement and regulations with assistance from FDA. In other words, FDA does harm assessments. This is something which has worked very well over the years, and the amendment here seeks to expressly exempt alcohol from requirements of the bill. In most instances, Food and Drug doesn't really have to be involved with regard to the question of safety. But I think the Memorandum of Understanding makes the amendment unnecessary. And truthfully, we don't know what the amendment exactly means. I will note to my good friend that it's never been the intent to interfere with the way that alcohol is currently regulated. And I would assure the gentleman that, in my opinion, this legislation, in view of the Memorandum of Understanding, does not. Now, the previous amendments to FFDCA have not included such language. So the amendment here, I'm afraid, would be causing us some problems with how it would be interpreted and how the courts or how the regulatory agencies would ultimately have their thoughts and actions interpreted, and what we would finally wind up with affecting us as the matter goes forward. And again, I would repeat to my friend that there's really, in my view, no need to exempt the provisions of the Federal Food and Drug Cosmetics Act when there is no such exemption in other provisions of the Federal Food, Drug, and Cosmetic Act. This committee has dealt with this question in other instances. And we did it when we addressed the question of sulfites and sulfates in food, which was a rather exciting thing because sulfites and sulfates were killing people. In any event, it's my view that there may be some specific issues here that need to be addressed. And I'd like to assure the gentleman if he'd withdraw the amendment, we'd be glad to work with him to try and see how his concerns can be met without affecting adversely the content of the bill. And I think if the gentleman would cooperate with me on this, we can work this matter out.
Will the gentleman yield?
I'm happy to.
I would note that in your statement to me, there are areas in the FAA Act whereby there are, with example on labeling requirements, whereby it's outside of the MOU and FDA retains some of its authorities, and those would be such as for wine coolers, for example, instead of wine, if it's below a certain percentage of alcohol. So while both of these agencies have jurisdiction over alcohol, the MOU covers pretty much everything, but there are some things that fall out. What I was seeking to do, and I'll work with the gentleman between now and the full committee, is that we have a system in place that is working very well. And when you're seeking to bring them in now to these other requirements of record keeping, registration, track and trace requirements, fees, in a system whereby it's already working really well, I'll withdraw the amendment. I've worked well with the gentleman in the past, and I want to work and see if we can find an accommodation for all the members in which share this equal concern.
We're not out, if the gentleman would permit me to reclaim my time.
Yes.
We're not out to create troubles for BATF, although there have been times I did want to do so in other connection with other matters. But the harsh fact of the matter is, I'm not quite clear what this does, and I would observe that Food and Drug does regulate a lot of things, like food additives, things that fall under the category of medicine, colorings, flavorings, and things of that kind, which are heavily full of alcohol, because that's the only way you can get the particular substance into solution. And I just don't want to let those kinds of things come in or be manufactured in an unsafe fashion. So I'll be delighted to work with my friend. If he'll withdraw it, we'll try and get this fixed.
Gentleman has withdrawn the member.
Mr. Chairman,
Oh, I'm sorry. Mr. Barton.
I want to speak in favor of the amendment just briefly. Chairman Waxman, I don't believe, is in the room, but he and I have had several discussions over the course of the last several months about bipartisanship and working together. And in a meeting that I believe you were in, Chairman Plone, with Mr. Deal and myself last week on the general issue of health care, I said don't automatically assume that because it's a Republican idea or amendment that it's bad. And generically, y'all agreed with that. People can look at sets of facts, the same set of facts, and come to different conclusions, and I think that's a situation that we have here. Chairman Dingle says that he's not trying to change the relationship between FDA and the Bureau of Alcohol and Tobacco Tax. Mr. Booyer says he's not either. He's just trying to make sure that the existing relationship stays the same, and since this is a bill about food safety and you know the classic definition of alcohol, kind of generically it can be classified as a food, but in reality most of the alcohol products are not. So what Mr. Booyer is trying to do is maintain that relationship and say that this memorandum of understanding that Chairman Dingle has referenced remains as is. And Chairman Dingle says that he thinks this would undermine it, and Mr. Booyer says that he thinks it would ratify it. So here's if Mr. Booyer wants to withdraw this amendment, that's his prerogative. But I would hope if he if he does choose to do so, that between now and full committee, there really will be a meeting of the minds, because this is an example of an amendment that is not mischievous, it's not nefarious, it's not in any way intended to undermine the basic concept that's been worked out at the staff level and the member level. It's meant to make sure that these products that are sold in all of our districts are regulated like they have been under the regulatory authority that has been worked out. So I see no harm in the amendment. I respect Chairman Dingell, and if he thinks there is potential harm, I think we should work to solidify that, to alleviate that concern, but hopefully some version of this would be in the bill at full committee. And with that, Mr. Chairman, I'll be happy to yield.
Spoken against the amendment. I'm just saying that there are questions here that got to be answered, and I want to work with the gentleman. We want this a bipartisan bill, and I want to satisfy the gentleman from Indiana. I also want to see to it that we don't make any surprises for ourselves later on.
I understand.
And if we work together, I think we can get this thing fixed up to satisfy everybody.
With that, I yield back.
Let me just mention, we have about 5 minutes. Does the gentleman seek to withdraw the amendment, or?
I'll withdraw the amendment and we can go vote.
All right. Thank you. The amendment has been withdrawn. We have 3 votes. After those 3 votes, we'll come back immediately and begin with any other amendments to the manager's amendment. Subcommittee meeting is in recess.